future judges and aspirants. Pahuja Law Academy has brought to you landmark cases on Bhartiya Sakshya Adhiniyam 2023. These cases are important from the point of view of both preliminary and mains examinations. So, let us begin this video by our very first important case. Dandan Mishra versus State of Bihar. This is a case on circumstantial evidence. This case is considered to be an authority on circumstantial evidences, although there are many landmark cases on circumstantial evidences, but this case has been reiterated time and again by the apex court. It was held in Dandan Mishra versus State of Bihar that circumstances which are relied upon to convict a person, they should be fully and completely established so as to prove the guilt of the accused and not leave any trace of the innocence of the accused. Absence of explanation or false explanation of an accused may also be considered a circumstance against him. It may be considered a circumstantial evidence against such accused. Next case, Kuruma versus the Queen. 1955, a very old case. Admissibility of illegally obtained evidence was discussed in this case. The admissibility of illegally obtained evidences are discussed again and again because sometimes the evidences are obtained by not following proper procedures by the investigating agencies or police officers. So, in this particular case, it was held that the test that is to be applied in considering whether the evidence is admissible is whether it is relevant to the case at hand and the court is not concerned with how it was obtained. If that evidence is illegal but nevertheless it is relevant for the case, then the court will admit such evidence. This case has also been repeated time and again in so many landmark cases. In R.M. Malkani versus State of Maharashtra 1973, apex court reiterated Kuruma versus the Queen. Ratton versus Regiment. Ratton versus Regiment is an English case. The doctrine of res geste was discussed in Ratton versus Regiment. The judge must be satisfied that the statement was made so clearly in spontaneity or involvement in the event that it could not have been concocted or adapted by the speaker. The judge has to make sure that there was no opportunity for someone to influence the judgment of the speaker, the judgment of the person who is giving the statement. Then only such statement can be said to be made in the same transaction. If there is any scope of manipulation of such statement, then such statement is not a good statement. Let's move on to the next case. Mirza Akbar versus King Emperor, 1940 Privy Council. This case is related to section 10 of the Indian Evidence Act. In this case, it was held that the words that are being said or the acts which are being done by persons in a conspiracy, they should be done when the conspiracy is on foot, which is meaning thereby that the conspiracy should be moving on in that point of time. If the conspiracy is already completed, then anything which is said by one conspirator in the absence of the other with reference to the past acts done in actual carrying of such conspiracy, then such a statement cannot be used under section 10. Because that statement is now being made about something that was done in the past and it is not in reference to the common design anymore. The common design has ended or it has been completed. Let us move on to the next case. Dakpandi versus State of UP. 1981, this is an important case on the plea of alibi. Again, there have been many cases on the plea of alibi, but Dakpandi is considered to be an authority and it is reiterated till now by the Supreme Court. The plea of alibi was defined, it was discussed at length in this case. It means the physical impossibility of the presence of the accused at the scene of offence because of his presence at another place. In this case, apex court held that the plea can succeed only if the accused is able to show, is able to prove that it was impossible for him to be at the place of the crime at the time when the crime was committed. because he was so far away from the crime scene that it could not have been possible for him to commit the crime at that particular place. So, let us move on to another case. Pakala Naran Swami versus King Emperor, 1939. This is again a very landmark judgment. In this, confession was defined. A confession must either admit in terms the offence or at any rate substantially all the facts which constitute the offence. Confession ये हो कि उसमें ये बताया जाए कि क्या क्या एडमिट कर रहा है ऑफेंस, या फिर ये हो कि सारे फैक्ट्स जो कि एक ऑफेंस को कंप्लीट करते हैं उन फैक्ट्स को जो है एक अक्यूज्ड स्टेट कर दे, उन फैक्ट्स को एक अक्यूज्ड बता दे, देन दैट स्टेटमेंट विल बी नोन एज अ कन्फेशन. This case is also an authority on dying declaration. When we talk about dying declaration, it was held in Pakala Narayan Swami that the circumstances which lead to the death of a person could be not immediate. He could not have had any prior intention or any prior knowledge as to that he was going to be killed. He must not be having the knowledge that he was going to be killed. Rather, the statement that he made was only pointing out to how he actually died. Then, in those circumstances, that statement will also be considered as a dying declaration, even if it was not made immediately before the death, even if it was made a day or 2 days before the death, but it points out in the direction as to how that person died. That is the case of Pakala Narayan. Next case that we have is Palvinder Kaur versus State of Punjab, 1952. In Palvinder Kaur versus State of Punjab, the admissibility of inculpatory and exculpatory statements given by the accused were discussed. When a statement is inculpatory, that means the accused is stating something that will most definitely criminate him in the crime. When an accused is talking about exculpatory statements, then an accused is just stating that he has not committed the crime. So, the inculpatory statements tend to be confessions and the exculpatory statements are not confessions. Now, in this particular case, it was held by the apex court that a statement that contains self-exculpatory matter cannot amount to a confession. The court must read confession as a whole. It cannot accept the inculpatory part and reject the exculpatory part, which means that if a confession is made up of two statements in which in the first part the accused is claiming somehow that he has not committed the offence, and in the other part the accused is claiming something inconsistent and telling that he has committed the offence, then the court cannot accept the inculpatory part which proves him innocent and reject the exculpatory inculpatory part that proves him guilty and reject the exculpatory part that proves him innocent. However, this case was later on partially overridden. This was overridden by Nishikant Jha versus State of Bihar. Yes. In Nishikant Jha versus State of Bihar, the apex court held that if exculpatory part of a statement is inherently improbable, then and it is also contradicted by other evidences, then the court may convict the accused piecing the inculpatory part with such other evidences. Whatever the accused is saying as regards to his innocence, if such a statement is not consistent with other evidences, then the court may reject that exculpatory statement and it may adopt the exculpatory statement, admit the exculpatory statement along with those other evidences. So now the court has said that a statement which is both inculpatory and exculpatory can be broken down into two, and the exculpatory part can be used as evidence against a person if there are other evidences to support the case, and if the inculpatory part seems, if the exculpatory part seems completely improbable. Let's move on to another important case. State of Bombay versus Kathikalu Oghad, 1961. In this case, the apex court discussed the constitutional validity of section 27 of the Indian Evidence Act. Now, using the information received under 27 is not an infringement of Article 20 Clause 3, which is against the right of self-incrimination. It is a protection against self-incrimination. Now, unless compulsion is used, in the apex court it was held that if such a statement under 27 was derived out of the accused by using some techniques which are coercive in nature, which are compulsive in nature, torture, third degree treatment, etc., then that statement would be completely irrelevant, it would be inadmissible in the court of law. Being a witness against oneself was limited to the information given from personal knowledge. Apex court held that being a witness to himself only means that the statements an accused is making about which he knows. It does not mean giving finger impressions or any other kind of tests or bodily fluids. So, in this particular case, the physical specimen like fingerprints was excluded from the protection of Article 20 Clause 3. So, which means that a person may be compelled to give his fingerprints and it would not be a violation of Article 20 Clause 3 of the Constitution. Moving on, Kashmira Singh versus State of Madhya Pradesh 1952. In Kashmira Singh versus State of Madhya Pradesh, section 30 of the Indian Evidence Act was discussed at length, and it was held that a confession by a co-accused who is being jointly tried with the accused may be considered by the court, but it does not amount to proof. It is not a conclusive proof. Such confession cannot be taken to be a substantive evidence. It can be weighed with other evidences. It can be used to corroborate other evidences against the accused. If there are already other evidences existing against the accused, then the statement of a co-accused may be used to corroborate such evidences. Kushal Rao versus State of Bombay, AIR 1958. In this test, the apex court has discussed the reliability of dying declarations. The test of reliability of dying declaration was laid down stating a few circumstances in which the court must take extreme care. For instance, if there was enough light at the time of crime that the witness was able to see the accused, or it was held that there are certain circumstances wherein the accused is not of proper mental or physical health. He may be old person. So, the witness was an old person. So, did he had a proper chance of looking at the accused, and all the other circumstances of the cases must be seen. So, reliability of the dying declaration can be made sole basis of conviction. This was held, but there is no rule of law or prudence against it. The court must closely examine the circumstances of the dying declaration. Whenever a dying declaration is made, the court must closely examine the circumstances as to whether the person who died was completely able to see the person who committed the crime and other things included. So, this is Kushal Rao versus State of Bombay. Dalal Singh versus State of Uttarakhand, AIR 2012. In this case, the apex court discussed the nature of an expert's opinion. The nature of an expert's opinion is such that it cannot bind the court. It cannot make the court functus officio. The court is not bound to accept a expert's opinion, because the court may either reject it or it may accept it, but wherever such circumstances appear that the evidence of an expert and an eyewitness are in contradiction with each other, then in this case court held that the evidence of the expert may be rejected and the evidence of the eyewitness may be accepted by the court. Dahyabhai Thakkar versus State of Gujarat 1964. This case was based on section 105 of the Indian Evidence Act, which talks about the burden of accused to prove his own defense. The burden of accused to prove his own defense was discussed, and it was held that this burden which rests upon the accused under 105 is no more than the burden which rests upon parties in a civil suit, which means that the standard of proof for accused is very low. If the accused can create a reasonable doubt in the mind of the court that he is innocent, then he will get the benefit of such doubt. This is the case of Dayabhai Thakkar versus State of Gujarat. The accused only has to bring a reasonable doubt in the mind of the court in order to prove his defense. Dagu versus State of Maharashtra, 1981 Supreme Court. This case is important from the point of view of two legal aspects. The first one is that there is no antithesis between section 133 of the Evidence Act, which talked about the accomplice, testimonies of accomplice, and the illustration B to 114 of the Act, because the illustration only says that the court may presume a certain state of affairs, the court may presume a certain state of facts. Now, the court may presume that no reliance can be placed on the evidence of an accomplice unless that evidence is corroborated in material particulars. This is the second thing that was held in this case. The illustration states that the court may do so. Court may assume that they presume that the accused is the accomplice is not telling the true state of affairs. The accomplice's testimony cannot be accepted, right, without any corroboration. But section 133 states that the accomplice's testimony is a valid testimony and it is a valid evidence against an accused. So, the court held that there is no antithesis between the two. One is merely stating that the court may behave in a particular manner. It is completely the discretion of the court whether it wants to go under section 133 and give enough weightage to the testimony of the accused, or does it want to go under section 114 illustration B of the Act. The next case is Panchanan GOI versus Emperor, 1930 Calcutta High Court. It is a very old case. In this case, the definition of a hostile witness was given. It was held that a hostile witness is the one who, from the manner in which he gives evidence, shows that he is not desirous of telling the truth to the court. Yes, a hostile witness was said to be someone who does not have any intention of telling the truth to the court, and his intention is clearly shown from the way he is giving evidence. That is to say that he is changing his statements again and again, even against the party who has called him in the court. So, this is Panchanan GOI versus Emperor, and it is important if you want to discuss the concept of hostile witness. That is all. Thank you for watching the landmark judgments on BSA 2023 or Indian Evidence Act.